Video number 2, sellers beware. Are you getting ready to sell your house without the help of an agent and want to make sure you don't break a contract or worse, end up in a lawsuit? Hi, my name is Todd Porter, also known as Utah Todd. I'm one of the founders of Synergy United Real Estate Group, the Sure Group. We are brokered by eXp Realty. We want you to succeed in the real estate game and have the best experience possible. So here are some of the things you need to pay attention to in the real estate purchase contract to ensure you hold up your end of the deal and don't end up in court or losing significant amounts of your hard-earned cash as due to failure to comply within the contractual obligations that you subject yourself to. We are not attorneys. Therefore, we are not offering legal counsel or advice. We are simply offering this information as a courtesy and hope to help you as you strive to sell your home without representation. First, the deadlines. Section 24 of the real estate purchase contract, also known as the REPC, shows all of the deadlines for the transaction. This includes 24A, seller disclosure deadline, 24B, due diligence deadline, 24C, financing and appraisal deadline, and 24D, the settlement deadline. When you accept an offer, we suggest putting these deadlines in your calendar to make sure you don't miss any of them.
Second, the seller's disclosures. Section 7 of the REPC provides a list of all the things the seller contractually commits to provide to the buyer or buyer's agent by the seller's disclosure deadline, which is the date on Section 24A of the REPC. This includes things like the seller's property condition disclosure, a lead-based paint disclosure if your home is built prior to 1978, a commitment for title insurance is referenced in REPC Section 6.1, a copy of any property management agreements affecting the property, a copy of any rental or lease agreements that will not expire prior to closing, written notice of any liens affecting the property, etc. Depending on the home, this to-do list can be quite extensive, and failure to provide any required documents prior to the seller's disclosure deadline would be considered a default on the seller's end. The third thing sellers need to be aware of is the additional costs and fees in the contract. Section 4 of the REPC covers most of these fees, such as HOA fees, special assessments, rental deposits, etc. Section 4.2 special assessments and Section 4.3c HOA fees are extremely important to look at because they state whether the buyer or the seller pays for these fees if they are applicable to the property. Also be sure to look at Section 10.1 Home Warranty Plan to see if the buyer is purchasing a home warranty plan themselves or if they're wanting you as the seller to pay for it. You don't want to accept an offer without being aware of any additional fees that fall on your shoulders.
Fourth, the contingencies of the contract. Contingencies are contractual rights allowing a party to cancel a contract without penalty. This includes Section 2.2 and all of Section 8. Section 8.3BI is one to really pay attention to. This section addresses the buyer's right to cancel prior to the financing and appraisal deadline. If the buyers have put a dollar amount in this section other than zero, that means that if they cancel, the seller will receive that amount from the earnest money deposit if they cancel after the due diligence deadline, which is specified in Section 24B of the REPC. If a buyer is extremely serious about buying the property, they might even put the full earnest money amount in this section to show that they are serious and now incentivized to stay in contract and purchase the home. Be sure to watch our video, FSBO conditions and obligations to be aware of when selling, where we give more in-depth explanation.
So, what happens if you as the seller default on the contract? Well, Section 16.2 of the REPC establishes that the buyer has 3 options. The first option is that the buyer cancels the contract and receives their earnest money back. If applicable, they can also elect to accept from the seller an additional amount equal to the earnest money as liquidated damages. The second option the buyers have is to keep the earnest money in the trust account and sue the seller to specifically enforce the REPC. The third option they have is to accept the earnest money back and pursue any other remedies available at law. Also, be aware that if the buyer chooses to accept liquidated damages, the seller automatically agrees to pay the amount upon the buyer's demand. Real estate contracts can be complex and confusing, so if you have any questions or if you want to pass the workload and stress on to someone else, give us a call as we are happy to help. My name is Chris Porter, also known as the Chris P. Realtor. I am a proud member of the Synergy United Real Estate Group, the Sure Group. We are brokered by eXp Realty. As always, make today an amazing day. And remember, real estate isn't just an agent's business, it's everyone's business.